Mr. Anthony Grose and Mr. Herbert Grose,
Yes,
right?
sir.
And each one of you are going to be arguing or presenting argument, is that correct?
We put in for time to split the argument.
Yes, sir. I mean, you both are going to argue, is that right?
Yes, sir. Yes, sir.
Okay. And y'all have already agreed how you're splitting the time?
Yes, sir.
Okay, all right, and that is how? Have you already shared that with Miss Angie?
Ms. Angie, 7-3.
Okay, good, good.
And
And look, bear with me, I'll let you ask me anything you want to in a minute, but at my age, I have to keep my train of thought or I lose it. You gentlemen have sat through this before, you've seen how the process works. Is there anything that you've got a question about or you don't understand before we get started? Okay, all right. Once you come up to the podium, of course, you know, you've heard me talk about the lighting system. I will need each one of you when you come up to introduce yourself. And so we know which person's talking. Second thing I need to know is, have you discussed whether you want rebuttal time?
yes, sir.
And you got that, Angie? Will one of you be making the argument or will you be sharing the rebuttal time?
Just one of us.
Okay, all right. And who will that be? Okay,
Anthony.
all right. I think that's everything I need to know. Is there anything that you have, any questions you have? Okay, all right. Gentlemen, y'all have worked out how y'all are sharing time?
We have, Judge.
Okay, excellent. All right, you may call the case then, Miss Angie.
Anthony T. Grose Sr. et al. Versus Charles Stone.
Good afternoon, Your Honor.
Good
I'm Anthony Grose, the appellate, and I stand before this honorable court in a pro se status representing my own self-claim of damages.
Okay,
This is a tort liability insurance, uninsured motorist collision coverage of a lawsuit claim against Mr. Charles Stone, the at-fault driver who is held financially responsible for the damages he caused on June 18, 2015, to my mother, Lucille Grose, in an on-scene automobile collision to a wrongful death. I have filed the required appellate briefs and a appellate reply brief along with transcripts of the issues that support the record on appeal arguments. This is an unprecedented civil action that are relevant for this honorable court to consider vacating the judgment for which the trial court erred that dismissed my pro se self-represented claims. After years of litigation in the Shelby County Trial Circuit Court in Division 7 before the Honorable Mary L. Wagner, judge presiding, she got it right. The court allowed the parties, pro se litigants, to proceed and present their disputes for a decision by setting the case for a trial by jury prior to the court's recusal of Division 7 judge. So the case, as the civil action passed by way of a recusal onto the Shelby County Trial Court Division 5, the Honorable Renata Hurd, presiding, accepted the lawsuit within days. The court, Division 5, unexpectedly, by appellate surprise, the court held a bench trial that dismissed all the pro se litigants' claim, citing Beard versus Branson, which under these circumstances do not apply to this case. We may see Elmore versus McCammon, 1986. The right to file a lawsuit pro se is one of the most important rights under the Constitution of the laws. Haynes versus Kerner, 1976. The United States versus Scito, 1976, and Conley versus Gibson, 1957. The question is, did the court err in its statement on argument? Another argument is, any and all unresolved matters filed and argued or otherwise presented to the court for reconsideration are hereby denied, for which the court denied a motion for a new trial a motion for judgment notwithstanding the verdict, a motion for change of venue, a motion to allow the appellants to proceed on their claims, or a motion for recusal of division, read or heard, the judge presiding. Another argument that we have is also a cause for assessment against the plaintiff and appellant. The American rule is a rule in the United States justice system that says two opposing sides in a legal matter must pay their own attorney fees or expenses regardless of who wins the case. The rationale of this rule is that a plaintiff should not be deterred from bringing a case to the court for fear of prohibitive costs. The appellate court has held the wrongful death statute must be strictly construed against the maintenance of any right of actions not expressly provided therein. Railway Company versus Lilly, 90-10. Hogan versus McDaniel, 204 Tennessee, 23-5-319. Appellants herein argue that it has been well established by the court that their wrongful death claims as individuals are valid before the trial court to be rightly adjudicated to be fairly settled before the trial court. Pursuant to the Tennessee Code, definition of a wrongful death is found in section 25106 of the Tennessee Annotated Code. We as the appellate feel and believe that this case should be remanded back to the trial court to allow us to proceed in a pro se status, because multiple actions may not be brought to resolve a single wrongful death claim, although there are other siblings in this case. There's a probate case still open for settlement in this case for claims for which my mother paid an insurance policy that is still open. And that's pretty much it.
Okay.
Thank you, sir. I run out the rest of my time to Mr. Herbert. Thank you.
Yes, sir.
Good evening. I'm Herbert Grose, the appellant standing before the honorable judge in court in a pro se status, representing my own claims and damages in this case. The court awarded me substitution for Lonita Grose, my sister, to stand in place in this position. I'm asking that the court to vacate the trial court judgment in this case. Okay. Any questions?
Thank you, sir. Gentlemen, you still got your rebuttal time. All right, we will hear from the appellate.
Thank you, Honored Judges. Good to see you. Good afternoon. Andrew Owens from the Memphis Bar, representing the defendant Charles Stone. I've heard...
How are you splitting your time?
I'm getting all of it.
Oh, okay. You're not arguing?
I may say amen at the end. I don't plan on using all of it. I guess if I quit with some time left and Mr. Moore realizes I've negligently omitted something, he would be allowed to proceed. But that's the way we've foreseen this going.
That's fine. Go ahead.
Well, I heard the gentlemen, and they're nice gentlemen. We've enjoyed working with them. I have every respect for them. And of course, we're, since day one, been saddened by this tragic accident that took their mother's life. We continue to say that it's not our client's fault, but that's not really the point here today. But I heard them both introduce themselves to the court by saying that they are here representing their own interests. And if that was true, we might not be here today, but that's just simply not the way the complaint is drafted. These gentlemen refer to, in the first paragraph of the complaint, it says the plaintiffs, as co-administrators of the estate, hereinafter referred to as the estate, or the duly appointed representatives. Paragraph number 3, the cause of action for the plaintiff, the estate, This paragraph 10, the plaintiff, the estate. There's, after 8 years of litigation, this is the second filing, and on the eve of trial, it was in that posture that these gentlemen were representing the estate, not themselves. There are other errors. Of course, we've cited Beard versus Branson. It's a mixed bag for us. It cites for the proposition that Judge Hurd based her ruling on. Of course, Beard had a distinguishing factor, and that is the individual that filed the lawsuit was the sole surviving spouse of the deceased in that case. And when you look at that case and see the way the complaint was drafted, the spouse was the sole plaintiff. It was not in any representative capacity. And it really was clear in the Beard case that the person that filed the lawsuit that was ultimately deemed to be a nullity was filing for his own interests as the sole surviving spouse. These gentlemen, of course, are not the surviving spouse of Ms. Grose. She was not married at the time of this incident. And based on the drafting of the complaint, the only way that it can be construed is that they were representing the estate in a representative capacity. And there are other pleadings that I've cited to the court that showed that they also were attempting to recover for their brothers and sisters damages as well, which again is practicing law without a license. So we believe that the proposition that Judge Hurd relied on is accurate. These gentlemen, admittedly not lawyers, filed this lawsuit in a representative capacity and a representative capacity alone. And of course, the court has the power to and the authority to preserve the sanctity of the practice of law and the judicial system. And we assert that Judge Hurd's ruling was correct and on point and should be upheld.
Was there a request to amend these pleadings?
Never. There's never been a request. Now, there was an amendment, but that was just to substitute one administrator for another. But never a request for amendment, not up to this point, to amend it to allow these individuals, the heirs, to sue for their individual capacities. And this issue of a nullity and relation back is probably secondary here. That would be more in the forefront if such a motion had been filed, whether or not there was anything to amend, whether this concept of the void ab initio and a nullity operated to prevent an amendment. But no, there's never been any attempt made to amend this complaint to allow suing in its in a non-representative capacity.
I understand, and I may be inaccurate in this, that there are several post-trial or post-judgment motions pending in the trial court. Is that accurate?
Well, these gentlemen filed a couple of motions after the judge ruled, and then they filed their notice of appeal. So we were airborne at that time. But if these gentlemen's, if the court finds that these gentlemen's complaints were a nullity, then so is the filing of those motions. I mean, if they're not authorized, if Judge Hurd was right and they're not authorized to file this complaint, then they're not authorized to file anything in this lawsuit. Thank you.
Thank you.
Court, please, I'm Robert Moore, the Memphis Bar. My amen will take about 2 minutes, I think, because I echo everything that my friend Mr. Owen said. He and I have talked about this, and the point that I made with him is the point that I'd make with you. Judge Hurd is either right or she's wrong on the issue of whether or not what was filed was a nullity. I hate to be simplistic, but she's right or she's wrong. If she's right and it's a nullity, then everything that was filed post-order is likewise a nullity. I was listening carefully earlier when you were talking about interlocutory orders and such as that. knowing that we would have to address that at this point. So everything that was done from day one until before we got in the car to come up here has been a nullity. There has never been an amendment. And although they say to you that I'm representing myself, Judge Stafford, Judge Golden, Judge McGee, the fact is in everything they filed, they said they're doing it in a representative capacity on behalf of the estate as co-administrators. That's different, isn't it, from the Beard case where the complaint was styled on behalf of the plaintiff as the surviving spouse and individually. That's why that case survived. That's why this case cannot.
Thank you. Gentlemen?
The original complaint was filed on April the 19th, 2018, and the heading of it was Lonita Grose Anthony, administrator, and Anthony Grose, co-administrator of the estate of Lucille Grose. It's in volume 1 at page 1. And if we go to page 10 of the complaint, in same volume 1, it states pro se. So, that being said, there's 3 entities to this complaint. As administrator of a probate case, which is open, it is the duties of the administrator to go and gather assets. And what we're here today for is assets of an insurance policy that's open, which my mother paid the estate, and it's due to siblings. It's due me to place in the probate court. So we have a wrongful death case, which, as I stated, Judge Hurd got it right to let the case proceed, and even Judge Hurd stated in the transcript that the probate laws in this state are squirrely, and that she mentioned that in order that she didn't know whether it was within her jurisdiction to allow the case to move forward as a pro se or break it up into 3 different parts. So in the rebuttal, I asked that the court vacate the administrator part and let me proceed and my brother proceed in the pro se state to move forward in this case. She said it was not within her jurisdiction, and she said it was up to us to bring it to the appellate court and let the appellate court make the decision. And like I've stated, Byrd versus the case in Byrd, it doesn't apply in this case. That's all I have.
Thank you, sir.
Thank you.
Gentlemen, what we will do is take this matter under advisement. We will review the record, review the briefs, conduct our own research, and we will prepare an opinion. And when that opinion is filed with the court, it will be mailed to each one of you, okay? All right. Thank you, counsel, and we will stand in recess to the call of the next docket.
All rise.